So I'm happy to welcome you to this conference on the possible consequences of a possible Brexit. We had hoped to be able to streamline the conference online immediately, but it has not proved possible. So we are recording the conference, and it will be put on our website as soon as possible for all those who have not been able to attend today. Our speaker today is Maître Louis, the lawyer of Union Syndicale. I think he will explain you most of the possible consequences of Brexit. As you might know, the polls are undecided. According to some newspapers, there is 1 point in favor of Brexit or 1 point in favor of remaining in the EU. So there is a real risk of Brexit. Now I'll leave the floor to Maître Louis. Thank you.
Thank you, Felix. And first of all, I apologize for my very, very poor English. When Felix talk about a real risk, it's a reality because I don't know if you want, but yesterday it was a referendum in Netherlands about the agreement between EU and Turkey. And the referendum reject by 61% the agreement. And in the French newspaper Libération, Jean Quatremer talk about a possible Netherlands exit. Okay. Brexit is a very exciting political and legal subject, let me say, for all of those who are not directly affected. However, it entails a large number of consequences, in particular the payment of pension, reimbursement of travel expenses, the system of insurance coverage against the risk of illness, invalidity, and so on. If the referendum conclude to a Brexit, what are the consequences? It's no immediate consequences. Let's be very clear. In accordance with Article 50 of the Treaty on European Union, if a member state decides to leave the Union, is expected to notify to the European Council of his intention to leave the Union. And he is obliged to negotiate an agreement setting out the blueprint for withdrawing in the light of the European Council recommendation. Then it means very clearly that the referendum will be one thing, the UK government has to take after that its decision and perhaps to notify to the European Council its intention to leave. But this is the real start point of all the processes. The paragraph 3 of Article 50 of the treaty foreseen that the treaties will cease to apply to the state from the date of the entry into force of the agreement, or failing that, 2 years after the notification of the intention to leave, or on a date fixed unanimously by all the member states of the European Council. It means also that the notification of the intention doesn't mean anything except the obligation to start the negotiation and to find an agreement in officially 2 years, but everybody knows that it will be impossible to negotiate all financial, social aspects with the state who decide to leave the Union. For me, the consequences of a possible Brexit are then more a political than a legal nature, and have to be negotiated between the member state and the country which living. Which are the consequences for the UK staff member in the EU institution? And I think that this is the real subject of this intervention. First of all, it's very, very, very difficult to know how much official and agent are concerned. Follow a report of the Commission, it's probably around 1,000 officials of the Commission who will be concerned. I was yesterday in Luxembourg, in the Court of Justice. They are talking about around 800 official and agent in Luxembourg. Then probably that it must be between 2,000 and 3,000 persons who will be directly concerned by Brexit. We have to understand that as official or agent, first of all, you are not a UK official working in a European institution. You are not a UK agent working for a European institution. You are, in accordance with Article 1st of the Staff Regulation, an official of the EU. And for me, I'm a little bit in trouble, because if a member state decides to leave the Union, and if the consequences will be automatically that all the citizens of this country will have to leave, it means that we don't have a staff working for the EU. We have then 28 member state officials working for the EU. The staff regulation is very clear. You are an official or an agent of the EU, full stop. The staff regulation and the COS, it's a very clear legal system. The judge, the member state, the citizen don't have the right to extend or to restrict the staff regulation by internal rules of so on. The only possibility is to take a new rules will have the same level as the staff regulation. It means a decision from the European Parliament and the Council at this stage. I think that you have to remember that for the first enlargement, when UK enter in the Communauté Européenne in this time, the Council decide to adopt a specific decision with derogation with the normal rules of the staff regulation. For which reason? It was first necessary to recruit UK officials. And for this reason, in accordance with this specific rule, it was possible to organize general competition only for the UK, the Irish, and the Danish citizen. First thing. Second thing, it was also authorized for the EU institution to organize open competition, not to recruit officials on the lower grade, but well on each grade of the career. It means in this time A7, A5, and also A3. And of course, in this time, the E2 and E1 for Director and Director General. The staff regulation provide in the Article 28 that to be recruited, a candidate must have the nationality of a member state. This is Article 28 in the chapter relating the recruitment. This Article 28 provides also that the official have to enjoy his full rights as a citizen. I don't know if you know, but a UK citizen who live during 15 years UK lose his civil rights. And to recover their rights, you have to prove that during 15 years he is back in the country. It means that if we have a restricted reading of Article 28, the most of your UK citizens are illegally official because you are no more in accordance with this obligation to enjoy of your right as citizens. Then, in my view, we have to be really careful for the interpretation of this rule. According to Article 41 of the staff regulation, a non-active statute ensues when an official has been affected by a measure reducing the number of posts of his institution. We have really a problem with this rule because you have 4 conditions. First, the appointing authority, after consultation with the Joint Committee, have to decide which type of posts are affected. Normally, the UK, except the translation unit of the interpretation unit, are nominated in each directorate of the institution. Then it will be very difficult to point out which posts will be affected if it's a Brexit. Second thing, to decide which post and which official will be affected, the appointing authority has to take into account the official ability, efficiency, conducting the service, family circumstances, and seniority. I don't think that if UK decide to leave, your ability, competencies, and conduct on the service will be changed. Third condition, for a period of 2 years from the date of being assigned non-active status, the official has priority of reinstallment. I don't know if we have a very restrictive reading of Article 28 and 41, or it will be possible to reassign a UK official who is put in such non-active statute. And the fourth condition, of course, the official will receive an allowance which is calculated in accordance with Annex 4. And before, when it was an enlargement, what we say about the application of this article, it was a golden check. Then for me, Article 41 will be very difficult to be used as a ground to decide to dismiss a UK official. In this view, we have also to take account that if we use this rule, it will be, in my view, a problem of discrimination. Because if it's all the UK officials affected by this decision to apply the non-active statute, it will be perhaps possible. But we know also that even if a Brexit will happen, the European institution will need to work with a lot of UK official or agent. For example, only in the unit, in the Department of Translation and Interpretation, I think that it will be very difficult to work without officials who are able to speak and to work perfectly in English. We have also Article 49. It's a compulsory resignation. An official may be required to resign, only where he ceases to fulfill the condition laid down in Article 28A. We have already talked about this. Article 39, it's an official within secondment at his own request. We have also Article 40, the official in leave on personal grounds. And to be short, an official or an agent who are in invalidity, and when his health problem disappear, he has the right to be reintegrated at the first vacancy. In this case, it's possible to apply Article 49. In my view, it will, first of all, it's very limited cases applicable. It's the first thing. And for me also, if you are in invalidity, it's only because you are covered and you pay for this against the risk of invalidity. It's for me a right. And if they apply Article 49 to say, okay, you are no more unable to work, you have to work back, and to say, yes, but because your country is out of the Union, it means that for you, you don't have any right, no unemployment allowance, no right to be reintegrated, we will have a really very big problem. I was yesterday before the Civil Servant Tribunal, and we were discussing about the consequences of a very difficult case, but concerning the application of a medical reserve with retroactive effect. And as personal consideration, the President asked us to try to find a friendly solution, and he repeat the institution have to take account with the very damageable consequences for such application with retroactive effect. For the question of the pension, the situation for me is very clear. If an official is already retired, or if an official retired before the delay provided by Article 50 of the treaty, it's an obligation, the payment of the pension, it's an obligation for the European Union. It's very clear. For the person, the official or agent, who will be in service less than 10 years, it's also very clear they have the possibility to go out and to ask the transfer of their pension right in another pension scheme, national of private scheme. The problem is only for the official and agent with more than 10 years seniority, because after 10 years you are entitled to receive, when you will reach the age of the retirement, the pension. And this is a problem. It's not a legal problem. It's a problem will be negotiated between the 27 and UK. It's then for me a political problem and no a legal problem. If it's no agreement, in my view, if you have 10 years seniority, you have a right for the future, and it means that if it's no agreement, you will have the right to receive for this part of your career the pension from the Union. Now we have a very, very big problem that everybody knows that you pay a third of the pension fund. Each member state has to pay 2/3 of the global sum for the pension. During the negotiation of the condition for the retirement of a country, an agreement must be taken. And I think that it will be very difficult because the sum will be very, very high. It will be in milliards of euros for quite each country and, of course, for England. For the agent. For the agent, we have the same rule. To be recruited as agent, you must have the nationality of one member state, full stop. In my view, you have a contract for a determinate or indefinite period. If it's for a determinate period, it's very easy. The institution, the appointing authority, don't have to do anything except to inform the agent who is concerned that the contract will be no renew, full stop. If it's an indefinite period doesn't mean that you are a permanent agent. Article 47 of the COS is very clear. If you are an agent recruit for an indeterminate period, the appointing authority has the possibility to notify a notice calculate in accordance with your seniority. It's between 3 months and 9 months. Then it means that for me, it's not really a problem of a Brexit. For every temporary agent or contractual agent, it's possible to terminate the contract by the notification of a notice. For the official, no UK citizen, or for the UK official who will remain in service, the situation will be very strange because UK will become a third country. First of all, the representation will change in the representation. It means also that in this case, Annex 10 will be applicable for all the official and agent working in the embassy of EU in UK. Now, we have a lot of rules. I mean, Article 17 of Annex 7 of the staff regulation, and you have the right, if you have a child, or if you have some obligation in a country of the Union, to ask the authorization to transfer it with very interesting condition for a maximum of 5% of your salaries. The condition is the transfer must happen in a member state country. It means that this rule will disappear. It's perhaps, and before to answer to the question, you have the situation of the European school. The purpose of the school is to educate together children of the staff of the European Union. The staff of the European Union. It means that if it's a Brexit, first of all, it's no more a right for the official to ask for their children to follow the European school, the first thing. Second thing, UK will have no more an obligation to participate in the financement of the European school. And you know that, in fact, follow the agreement concerning the European school, each member state second a number of own teachers and remain to pay there. And the union have only to pay the differential allowance. If UK is no more a member state, it will be impossible to second their own teacher. And I don't know what we will do, because I think that for a lot of nationality, they've decided to choose the UK section for their children, even they are not Brits. I think that it's a lot of problem. We talk really about very small number of problems. I was only focused on the staff regulation and the European school. For the rest, if you have problem, first we'll try to answer to your question now, or you have the possibility to send a written question, and we will try, if it's possible, if it's a question relating the application of the staff regulation, to answer in a very short delay. Thank you for you.
That the appointing authority can dismiss an official if he doesn't fulfill any longer the conditions of Article 21, 21A or something, or 21, which contain the condition of nationality. It is at least possible. I wouldn't say there is no obligation for, of course there is no obligation for the appointing authority to apply this, but there is a real danger that throughout the negotiation process of the Brexit, or without regard to that process, the appointing authority of the different institutions could apply this to all, or at least a part of the British nationals, and there is no other condition set out by the Article 49. I mean, there are other possibilities, other cases than those that of having lost the conditions of Article 21. But if you have lost them, you could be dismissed by decision of the appointing authority. This is the biggest danger, I think. And then for people, regardless of their nationality, three additional problems of all those that you already mentioned. One is those of our colleagues who have been recruited in the UK, well, from the UK, regardless of their nationality, but there is a notion of a place of recruitment, place of origin in the staff regulations. If Great Britain is no longer a member state, this place of recruitment or origin would be at some day outside of the Union, and that has consequences on people. Well, we had seen this in the staff regulation reform 2014, where the possibility of having a place of recruitment outside of the Union has been withdrawn. Second thing is those of our colleagues who have the tax domicile in Great Britain. It could be non-British officials, I mean, but it can be British or non-British. They can have the tax domicile in Great Britain. It is very different, I think, of or the situation is very different for somebody who has the tax domicile inside or outside the European Union. When the place where you have your tax domicile is one day outside of the European Union, it can have heavy consequences on taxation of your income or property, heritage, and something. And the third and last thing I would mention is the pensioners' problem. You said about the payment of, you told us about the payment of the entitlement to perceive pensions, but there are two more minor problems, but they are still there. One is about the weighting factor. If I remember well, pensions paid out in the UK for EU officials have a very attractive, actually, weighting factor for those pension rights acquired before 2004. I guess that this would be lost. So it would be have a direct consequence on pensioners already living there also. And also for those of us who will go to Great Britain and who have acquired a part of their pension rights before 2004. And the question you told about that is the taxation of the pensions. I mean, the protocol of privileges and immunity apply only to member states. And this protocol says that the salaries and pensions from EU institutions are free of income tax, by national income tax. When UK is not longer a member state and you perceive a pension or perhaps even a salary in the UK from the EU institutions, I don't know if it's likely, but it is at least possible that UK would require taxation on these amounts, which has a huge impact, a very huge impact on the net value of these pensions. And this could also arrive to people already living in Great Britain, not only those of us who can still decide under these conditions, should I really go to pension to Great Britain or perhaps prefer another member state. But there are, of course, we have already lots of people living there and getting their pension, and the taxation, in 2 years' time, it could be that they will have to pay tax on these pensions. And these are additional problems that come from a possible Brexit. And of course, I think that, as you said, it's lots of these problems are political problems that have to be addressed in the negotiations then that have to be run between the EU on the one hand and Great Britain on the other hand. But there are, I mean, all these questions could be politically solved by a good agreement. But there it is clear that there are very, very many different staff interests, I mean, for existing or past staff, that are in question, that we as a union have really to try to influence the outcome of these negotiations. We will need negotiations with our appointing authorities. It's not only in the council; it's also in the commission and so on. To get a satisfying outcome that people, I mean, individuals that are not responsible for the Brexit or something would not lose like 30 or 50% of their future income by this process. So thank you. Perhaps you want to answer this directly before giving the floor, or you want to collect more questions before?
Perhaps directly on it will be very short. First of all, application of Article 28A, the obligation of the nationality, yes, it's a possibility. then it must be applied to all the UK official and agent. If they don't do that, it's a question of discrimination. And we will open a lot of cases, complaint and application before the court, and it will be a disaster. It's the first thing. Second thing, the question of taxes. It's a very, very complicated problem. It's a fact that if UK is no more a member of the Union, UK will be a third country, un pays hors Union, as the other. And we have then to apply, for example, for the reimbursement of the travel cost, the annual travel, you will, and it's a very strange because if in the current situation, a Brit who is working in Brussels or Luxembourg, and if his place of origin is, for example, Tokyo, you will have the right for a reimbursement between Brussels and London. If it's on Brexit, you will have then the right with the specific rule if your place, your working place, it's outside the Union, in application of Annex 10, and that your place of origin is also outside of Union. And it's more interesting for you. Now,
If you are working in the UK, not in Brussels.
if you are working outside the Union, now, it's a fact also that the question of the weight factor for the pensioner will be a very big problem. But in my view, the pension in law is salaries with pay after your working time. Then the nature of the pension is salaries. And in my view, it's not totally impossible to see the obligation of the Union. It's to provide that you receive, in accordance with the principle of equality of treatment, the same pouvoir d'achat that another official who is retired in another country. And in my view, if a member state decide to take the exit way, or his own responsibility will be engaged in regard with the official and agent or the union. Or perhaps that the union will be responsible and have to return against the member state to ask the financial compensation. Then I think, you see, we open really a very, very, very difficult problem in law. And I think that really, if, and I hope that it will be not the case, but if it's a Brexit, I think that all must be solved on a politic problem and not by the court. And the real situation for me is that we are really in a new situation. It will be impossible to provide all the problems. It will remain, of course, a lot of problems. It means that it will be a lot of application before the court. And it's really what we need to do and what the trade unions have to do with the appointing authority, with the political, on the political level, to try to find the best agreement if a Brexit will happen.
So I open the floor for those of you who want to address specific questions. Okay.
Yeah, thank you very much. Two basic questions. You spoke about the role of the appointing authority. Does that mean that we could imagine that the staff in different institutions could be treated in different ways? And on your last point, just occurred to me, I'm slightly reluctant to go rushing ahead in the way that you seem to be, but if we envisage a Brexit, then will the disputes be automatically taken in Luxembourg, or will the British courts become involved?
It depends. If it's the application of the staff regulation, of course, the Court of Luxembourg will be the only court able to know such litigation. If it's consequences of the agreement between UK and EU, it will be really more difficult to know because the legislation don't provide this situation. Then I think that perhaps it would be possible to apply before a UK court. Second thing, it's, I think, 25 years ago, I was before the court of first instance, and I based my legal argumentation on the fact that in the European Parliament, the internal rules on the same staff regulation article was not the same. And I say, I don't understand. You have the possibility to take specific internal rules when the staff regulation it's not clear enough. It means that if it's so short the possibility to take these internal rules, it must be applicable for every European institution. The court say, forget it. It means that, yes, each institution will have a certain power of appreciation and also different need, for example, in terms of interpreter, translator, and so on. And it's for this reason that also we have to be careful, and it's also for this reason that I say that if the referendum will conclude for a Brexit, I think that the trade unions have to start as soon as possible a dialogue with the appointing authority to try to cover all the problems. And it's for this reason that it's also so important that everybody with a question, that everybody will make the effort to ask the question to the trade unions. Because it's impossible to imagine all the situation. And I think that if it's 1,000 persons, we are thinking about their own situation and their own problem, and they ask information, that then it will be perhaps possible to cut a lot of possible litigation. And please understand, I'm a lawyer. My job is to apply before the court. But you have to know that to go before the court of Luxembourg, it costs so much. And we know also, follow the statistic, that 80% of the cases are rejected. Then we have to be very, very, very careful. And we have to solve such problem on a political level and not on a legal level. Thank you.
Indeed, you should come with all your questions now and later on by email. I just wanted to relativize if there are several thousands that write us, our email system will have a kind of Stack Overflow. So I don't know. It shouldn't be several thousands, but we are not several thousand people here in the council directly concerned by Brexit. But all those who have real concerns, please send us your questions, and also you see how important the role of the trade union might be in the negotiation process. You have all interest to be a member of one of the unions, to influence and to make us stronger in order to have a real possible impact on the negotiations. So next question. Yeah, please.
Would having a second EU nationality help in terms of, for example, what Ben said about Article 49? And if so, should one apply for that second nationality before the date of the referendum on the 23rd of June or afterwards?
The date of the referendum have no impact. It's only the date of the exit who will be important. It's the first thing. The second thing, yes, it's a very good question, because don't forget that the main UK official don't have in Belgium or in Luxembourg or in France their fiscal residence. They don't pay, of course, social security. They don't pay taxes on the professional incomes. And for this reason, it will be not so easy to opt for second nationality. Now, of course, if you are an official with 2 or 3 or 4 nationalities, and if one of your nationality it's from a country we go out of union, you have always the 2 of the 3 other nationality, and you are not be affected by the exit of your country. Then yes, if you have the possibility, but for me it must be very clear, the date of the referendum doesn't do anything. It's now the real date, it's the exit of the country. Thank you.
A comment on the nationality issue, because I found out recently that those of us who have a special ID card, I think probably many of us would have that, are not eligible for Belgian nationality. So the only way, if we were interested in a Belgian nationality, would be to apply for the standard Belgian residency card, wait 5 years, and then apply. I just wondered if we could have a little bit more. Wasn't quite clear on the Article 49, because there seemed to be this worst case scenario that the appointing authority could decide to dismiss. You say it would have to be all EU officials, or all UK officials, that they couldn't do it for some and not for others, otherwise it would be discrimination. And that there would be no particular obligations towards us, such as some sort of a severance package or unemployment benefit. Or I was just wondering, is there some... We don't have any legitimate expectations, or is there some precedent from other institutions such as WEU, where we've seen that people have been dismissed and there's been issues with pensions? So, and also I wanted to ask about the Article 50 of this. No one mentioned Article 50 of the staff regs, which hypothetically could be applied to senior British officials. And if they do that, would that be considered as a discrimination against everybody else?
Only for the application of the Article 50. The higher management, it's a political decision, the nomination. Even if you have selection and so on. Okay. In any way, if you are Director General, Deputy Director General, Director, follow Article 50 of the Staff Regulation, the appointing authority have at each moment the possibility to dismiss you with all the financial consequences. It means it's the application of Annex 4. Nathalie will answer for the question of the nationality.
So regarding the nationality, of course, you have all special IDs that allows you to stay on the territory of Belgium. The loss of such IDs does not mean that you will be excluded from Belgium and from the territory, but it means that you are illegally on the territory. The only way to apply for the Belgian nationality is to fit the criteria of the Belgian law regarding the nationality, the Belgian nationality. And the fact is that the criteria and the situations are quite, there are only, I think, 4 or 5 situations where you are allowed to apply for the Belgian nationality. And the most important for you, if you want to apply after the Brexit for the Belgian nationality, you will have to be economically interesting for Belgium. It means that you will need to have a function, a salary and a work in Belgium. Could be self-employee or employee in Belgium, but you will have to have a situation in Belgium. We are not yet at that stage, but the fact is that it is now, especially with the problem of migration in Europe, it is very difficult to apply for European state nationality. So it will have consequences on that, but I'm sure that it will be discussed through the negotiations on the Brexit and the consequences of such Brexit, since it is important for all of the UK workers to have a legal reason to stay on the territory and to not be asked to leave the country as soon as the Brexit is voted. So don't worry about that. I'm sure that it will be, and it will probably be a question that will be raised before any discussion on the staff regulations, since you know that the European officials are not the priority on the Brexit situation. It's more the economy and all of that things that are more related to the country, the economy, the government. And so don't worry about the nationality. There will be most probably discussions and solutions on that, because I'm sure that for any problems, that will be a period in which there will be different solutions that will be found and applied in order to make a smooth movement to the real Brexit and consequences of the Brexit. So it's just about the nationality.
Thank you, Nathalie. Just please, one of you two would please come back to the question of, well, the combination or the difference between Article 49 and 50. The question was, if they apply Article 50, well, let's say they want to dismiss all UK officials in application to Article 49, and they apply to some of them the Article 50 instead of Article 49, wouldn't it be discrimination? And second question is, for those, let's say, worst case scenario, Brexit and application of Article 49 to all officials of UK officials of an institution, let's say the Council, for example, the day after having dismissed, what is the income of the concerned people? Will they have any unemployment allowance? What about their pension rights and so on, for those to whom the Article 49 applies?
In reality, if the appointing authority apply Article 49 or Article 50, yes, it's in reality totally the same, because the allowance is calculated by reference with Article Annex 4 of the staff regulation. You have a lot of small difference, but if you read Article 49, it's very clearly that they have to apply. Just a moment, because 49, not. It's no discrimination between 41, excuse me, and Article 50. For Article 49, yes, but you are not in the same situation. And for this reason, it's no discrimination, and you don't have the possibility to base an action on the legitimate expectation, because you are not in the same situation. I know that it's difficult to accept such situation, but you are not in the same situation, and legally it's impossible to invoke this difference, because you are not a higher manager, and then it's no discrimination. Thank you.
That means application of Article 49 would mean that people the first month after having been dismissed have no salary anymore, no unemployment allowance, and the allowance of Annex 4 that you are speaking about is applicable to Article 50 people, but not to Article 49 people, I think.
41.
Yeah, but not 49. Article 49 is the danger. Article 41 is not a, I mean, it's very, it's nearly impossible to apply this, but Article 49 says you can be dismissed by your appointing authority if you do not fulfill anymore the conditions laid down in Article 21, one of which is the nationality. And there is nothing foreseen. What happens then? I mean, if they wanted to apply it, that would mean that you just go like this, and you go with your pension rights. And even there we have seen lots of questions about what about pension rights later on for British. But that would mean that from one day to the next, people do not have any euro anymore or British pound.
That's precisely the consequences of the application of such article. And so it means for us as lawyers that the main issue will be to raise an action against the UK, since it is responsible for the Brexit, in order to compensate all the financial damages that will be, of course, claimed by UK officials and civil servants. So it's not a question of European procedures, but more a question of procedure against a country that has initiated the Brexit and that has to, of course, think about the consequences and the financial consequences of the Brexit, and he has to assume the responsibilities of such claims and damages.
Yes, I just wanted to add that, of course, we have many questions. We don't have any answers yet because everything will have to be negotiated. As regards Article 49, which is the real risk, even if it's unlikely that Article 49 would be applied, it would be applied to all UK officials at least, but even in this case, there would be negotiations. For example, one could very well imagine that the dismissal would not be automatic, would not be on the date of Brexit or on the date of the decision, but the appointing authority may take the decision to dismiss all UK officials who don't have another nationality. They can decide to dismiss them 1 year, 2 years, 3 years later, and they can, during that time, build up social security rights in the UK or somewhere else, just as was the case, for example, with auxiliary staff who were recruited before the 2004 accession and before the other accessions. There was also a system to give them social security rights, even if in the Council we had to fight for it because the appointing authority had forgotten some of the social security rights. But the idea is to enable them to build social security rights somewhere else. So I imagine that that would also be part of the negotiations.
I think that you can escape from Article 49 by the 50, but not by the 41. Because when you, with the application of Article 50, you are not anymore a civil servant. Then you have a droit acquis under the statute. When you apply Article 41, you remain a civil servant. Then, if the IEPN decides to apply Article 49, it will apply also to the people who are under Article 41.
Okay, next.
I'd like to respond to the lady who asked about the WEU. I happen to be the head of the unit of the residual administrative tasks of the WEU. So we are an agency of the satellite centre, which is based in Madrid, but we're here in the council building. What is very important for anybody to know about the WEU is it closed in 2011 and all the acquired rights were kept and all the obligations of the member states were kept. And that is why we're still paying pensioners, and we will still be paying deferred pensioners, so those who have not yet taken their pension, over the next, I don't know how many years, till something like 2080, I think the calculation is. what is important to note is that in the staff rules of the old WEU, it said quite clearly if a member state withdraws from the organisation, that the WEU may, I think the wording was may or could, not renew or not give a contract to those staff members of that nationality. And in that case, there would be a loss of job indemnity. At the same time, when the WEU was going to be closed, there was the unions got together and they, or the staff representation, and they negotiated a social plan which was on top of any loss of jobs. So they had special emoluments which kept them going while they were looking for another job or until they took their pension. So it might be interesting for the union to bear that in mind, that it's something that could be negotiated, is a social plan which takes all that into account. And the last thing, without boring you about the WEU, what was my last thing that I wanted to say? I can't remember what the last thing was now. Damn. I'll get back to you. But I did have one last point, and I've forgotten it.
You can ask the floor again if you want, if you remember your point.
Okay, I will. There was something very important, and I don't know what it was. Sorry, I've forgotten it. Thank you.
Okay, other questions? Yeah, please.
Just regarding the Belgian nationality, I've been to another conference organized by the legal advisor of the Commission, and apparently you mentioned something that seems fair to me. We are not in Belgium with an illegal ID card. We have a legit stay in Belgium, and apparently there are judgment against the Procureur du Roi that allows colleagues with an ID card to have the Belgian nationality. So I'd like you to dig into it, just to be sure. And I don't know. That's what I've heard. It was a year ago or 2 years ago that the Procureur du Roi says no, you cannot have because you don't have a legit card, you don't have a legit stay in Belgium. But well, we are here because you provided us. Well, Belgium provided us with an ID card, which is of course legit.
Was this man the person concerned by this case? So
it was Mr. The legal advisor was Mr. Buchenhout from the Commission.
No. And the person concerned by the loss of nationality, or the fact that he has an ID, a European ID card, did he lost his ID or not? Because with a ID from the European institutions, you are of course allowed to stay on the territory. So because you are from your work of the institutions, so you are totally allowed to stay on the territory. What I have said is that once you have no ID from the institutions anymore because you are retired and that you choose to come back to your country, you have no more the possibility to stay on the territory of Belgium without any Belgian ID card. It means that you will have the possibility to stay on the territory for 3 months or for other reason, but not on an indefinite duration period. So what I have said is that once the Brexit happens, there will be the question of those that will lose the ID from the institutions, allowing them to stay on the territory. The fact is that they will have, if they want to stay on the territory, maybe because of the children that are still learning in Belgium, they will have to apply for the Belgian ID card. And it means that they will have to fulfill the criteria of the Belgian law. So I fully understood that the person that was interested by this case or by the decision from the procureur still had his ID, but if it's not the case, I told you that you won't be required to leave the country and the territory. It's just that you will be in an illegal situation without any card allowing you to stay on the territory, which is the purpose of the European ID card. Yeah.
And apparently she said, because I have a special ID card, I cannot have it.
No.
Oh, sorry. So I got it wrong. Okay.
This is clear. The possibility or not to acquire the Belgian nationality doesn't depend on the question which ID card you have, but if you fulfill or not the conditions laid down by the Belgian law, and they are, if I understand well, they say that the fact that you worked you came to Belgium to work for the European institutions, you work here for, let's say, 15 years or so, that doesn't give you the entitlement to get even if you lived here during 15 years. And it's independent of the question of identity card that you have.
Into it because I was in a conference when another lawyer said the opposite. Said that there was judgment against the Belgian state for this. Sorry.
You can have a judgment, but no change in law. So the most important is to check the law about the nationality. But believe me, the national law about the nationality and the criteria that must be applied in order to check if you fulfill the conditions are very, very restrictive and changed because of this migrations politics. But of course, I told you, they will, I think, maybe change the rules regarding this appraisal of the fact that you stayed in Belgium for your work and that you had a residence in Belgium for the past and that you applied for the Belgian nationality once the Brexit is voted. But I cannot guarantee anything about the criteria of the nationality since it was not the topic of this conference. But I can check, of course, and I can provide the Union Syndicale with a short summary of the rules, and they will put that on the website. Okay, I will.
One last question, and then we have to stop because of the time running out.
I wouldn't have actually thought that you were illegally in Belgium if you got made redundant, because you would have some form of redundancy pay, you would have some form of unemployment benefit. Therefore, you would have an economic interest here, which you're not dependent on the Belgian state, you'd be dependent on something else. Therefore, your residency, your right to be a resident, should not be affected, and you should be able to apply for a Belgian ID card immediately.
You should be allowed to, you should be allowed to apply. But the fact is that it doesn't mean that you will be allowed to stay. So you will have to apply in order to have the Belgian nationality. And the fact is that the main criteria of the Belgian nationality, when you want to apply for the Belgian nationality, is the as you say, the fact that you are not dependent on the economically not dependent on the Belgium, and so that's the point. So you will have to prove that you have your own revenues, or that you live with someone that has revenues enough in order to live with you and to pay you the health insurances, the eating, everything, so that you won't be a charge for the Belgium. But it's not automatically accorded, and you will have to follow the procedure in order to have the nationality under another article of the Belgian law regarding this nationality. And so I'm sure that the law has to be changed once there is a decision about the Brexit, because it should not be so difficult to apply for the Belgian nationality, and they, according to me, don't have to apply or must not apply the same criteria than for other applicants for the nationality, the Belgian nationality, since you have a past with the Belgium and with the institution, and since Brussels and the Belgium is the center of the Europe, it must be taken into consideration, and I'm sure it will. But that's something very, very uncertain, at the moment.
Yeah, my point was more, we will definitely fulfill the criteria of not being financially independent on the Belgian state.
Yeah, if the fact is that regarding the economic part of the application, the authorities have a very high power of appraisal, and so it's not just a question of money, a month of revenues, or so. It's something very that is appraised in specie. So, so I cannot answer for your case, but the fact is that indeed, if you have money and resources enough in order to stay on the territory, and that you can prove that you won't never ever be a charge for the country. You must be allowed to stay on the territory and to have a permanent card in order to stay on the territory, of course. But it's something very special and depending on your own case every time. Yeah.
If I may add and perhaps conclude, don't forget that your situation as EU staff is only in regard with all the formality regarding the country where you are working. It's not in your favor, it's only in the interest of the institution. The goal of le protocole sur les privilèges et immunités, it's only to be certain that a member state will have no possibility to refuse to a staff member of an EU institution to stay in the country. And the only right that you have is that your institution transmit to the national authorities the list with the staff member who must be inscribed on the register without any formality made by you as staff member. For the rest, you have the same ID card, but you don't oblige to do personally all the formality to prove that you fulfill the criteria to stay in Belgium. It's nothing else. But please understand, it's only in the interest of the EU and not in your interest. Okay? Thank you.
Well, most people have already decided to go to lunch, so I recommend you to do the same during the period the canteen is still open. I thank you very much. And, we will make other conferences, as Nathalie said, during the next month on different aspects of the staff regulations. And if Brexit, we will know it, I think, during the European Football Championship, if England will leave or not. And if so, of course, we will analyze the situation then and make other public conferences on what is going on then. But we hope that we can avoid it. Thank you.
Perhaps the last thing, it's a very interesting paper, the process for withdrawing from the European Union. It's right by the UK government. We have, yes, we have an electronic copy of this. If you like to receive a copy, please you ask to the Union Syndicale.
Have a nice lunch.